With that, I would like to open up the public hearing for the city attorney and staff to present why we're here.
Thank you, Chair. Just at the beginning, there have been a lot of concerns raised about public participation in this process, raised to either council members or other city staff members, and so I'd like to just give an overview of the process to show where the public fit into the process. Those concerns related to this conditional use permit for New St. Andrews for the proposed use of a building in downtown Moscow. Like I said, there was a lot of misinformation and misunderstanding, I believe, and hopefully this will clarify it. I'm going to give a little overview of the process that has occurred so far and what should be occurring tonight. In accordance with Idaho Code and the Moscow City Code, the Board of Adjustment conducted a public hearing concerning the New St. Andrews application for a conditional use permit for the former CJ's building to operate an educational facility in the Central Business District of downtown Moscow. Pursuant to Idaho Code, the Moscow City Council has delegated the authority to decide conditional use permits to the Board of Adjustment, with the council acting as the appellate body for those who are grieved by any decision of the board and wishing to appeal a decision from the board. At the original public hearing, city staff presented the CUP issue to the board. The chair then opened up the public hearing for public input, otherwise known as the opportunity to be heard. The applicant, NSA, was allowed to present its position on the CUP. After the applicant presented, the chair invited any member of the public in favor of the CUP to address the board. Many did. The chair then invited those members of the public who may be in opposition to the proposed CUP to address the board. Again, many did. The chair then allowed those neither in favor nor opposed who wanted to be heard the opportunity to be heard and to address the board, and there were some. The applicant was then given the opportunity to readdress the board to comment or rebut any information that was presented from the public. Any interested member of the public was given due process to speak to the board concerning the CUP. The chair then closed the public input portion of the hearing for the board to deliberate and make a decision, which the board did by approving the CUP with specific conditions. 5 individuals subsequently appealed the board's decision to Moscow City Council as allowed per Moscow City Code. The council heard the 5 appeals at a properly scheduled public appeal hearing where only the appellants and the applicant were allowed to present their arguments based on the facts established in the record of the original public hearing. No new evidence or no new facts were presented or allowed. The council decided each appeal as a separate action. The council remanded one of the appeal to the board with specific instructions on what to consider at the remand hearing, which is happening tonight. The other appeals were denied. The council's role in the appeal of the board's decision was not to substitute its decision for that of the board, but only for the purpose to see that the board applied the criteria prescribed by statute or ordinance and did not act in an arbitrary manner in reaching a well-reasoned decision. The council could have remanded the matter back to the board in full if it had found that the board had misapplied the law or found that there was serious error in procedure. It would essentially be ordering an entirely new proceeding where the board would have to conduct a new public hearing on the CUP where members of the public would then be given another opportunity to speak. After hearing all the appeals and considering the facts established in the record, the council, pursuant to Moscow City Code, chose to remand the matter back to the board with instructions specifying what the board must consider at this public hearing. The board is hearing the remand this evening, which was properly noticed and is also pursuant to Moscow City Code, because the instructions were to have additional evidence added to the record, and the specific instructions did not include additional testimony. That was the requirement for the public notice. At the hearing tonight, staff will present the issues to be addressed on the remand as instructed by the council. Only the appellant and the applicant would be able to respond if there were any inquiries from this board concerning matters of clarification, something in there, if there is any. No other public input is to be taken, as the public's right to participate occurred at the original hearing. The board is to consider the information that the council instructed the board to consider and then must make a well-reasoned decision along with an accompanying reasoned statement based upon the original and the additional presented evidence. Any decision reached tonight must not be arbitrary and capriciously reached and needs to be based upon the facts established in the record. The remand to the board from the appeal to the City Council is part of the same quasi-judicial proceedings, which does not allow members of the board to communicate with members of the public on anything concerning the matter of the appeal, other than the opportunity where they were allowed to give public input at the public hearing. The public input portion, like I said, occurred at the original CUP. City Council also, since they're the appellate body, are not allowed to discuss this appeal with anyone during the appeals proceedings.
Marshall, you have a question?
Yeah, Rod, quick question. We are going to hold a new public hearing and look at the new evidence which the council asked us to look at. Can this meeting can this decision we make tonight be appealed again?
It depends on what the ultimate outcome is. And then it'd be the decision of the council whether they want to do it. Sometimes appeals from a remand, that would be the final decision, and then maybe the only recourse would be go to district court. But I don't know if that's decided. It depends on what the facts are.
Okay. Thanks.
Before Ryan starts, did anybody else have other questions for our city attorney? Thanks, Ron.
All right. Thank you, Mr. Chair. I'd like to thank everybody for joining us on the City Council's remand in part of a CUP application for an educational institution at 112 North Main Street in the Central Business Zoning District. So a little bit of background, as Rod had stated, the Board of Adjustment conducted a public hearing on April 25th, 2015, regarding the proposed education institution and approved the CUP application with the following conditions. Number one, the applicant would be required to provide 47 off-street parking spaces within approximately 1/2 mile of the subject property with the approval of the zoning administrator, and the applicant shall be allowed to phase in the off-street parking requirement by providing 50% of the required parking mitigation upon occupancy of the building, and the remaining 50% to be provided when the enrollment of the education institution use upon the subject property reaches 150 full-time equivalent students who are enrolled in education programs offered up to the subject property, or up to until 5 years passes from the date of the issuance of the certificate of occupancy of the building, or whichever comes first. So beyond that particular conditional use permit hearing, the City Council conducted a public appeal hearing on June 5th, 2017 to consider 5 appeals. After hearing the appeals and consideration of the record established by the Board of Adjustment, and having considered the issues presented by the appellants and the applicant, the Council sustained the Board's decision on 4 of the 5 appeals. On the appeal of Ms. Ryan Pilgrim, the Council remanded the matter in part to the Board of Adjustment for the following and sole specific purposes. Council's decision, Council remanded the matter in part to the Zoning Board of Adjustment for the following and sole specific purposes. Number one, for the collection of additional 12:30 p.m. public parking availability counts within 600 feet of the subject property, and entering said additional 12:30 p.m. parking count into the record of the subject application for further consideration by the board. Number two, the review and confirmation of the method of determination of the board's prior parking impact mitigation requirement. And number three, the review of criteria 4 and 7 of the reasoned statement of relevant criteria and standards signed on May 3rd, 2017, considering the prior record and the additional information to be entered in the record in conjunction with these remand instructions, and to make a decision upon the conditional use permit application. Council order of remand, again remanded with instructions for further consideration. Council clarified that the intent, or the intended action to the board for them to take is open the public hearing only to receive additional parking count information as instructed by the council, and review the method of parking calculation. And in light of the new information presented, criteria 4 and 7 of the RCS approved by the board. The board's action, again, is to open the public hearing, only receive additional parking information. And then within that, the overall, as stated before in those slides. So going into the parking situation, the original parking study was a quick assessment of the overall parking availability downtown, which consisted of gathering information from a 2008 parking exhibit Public Works created with aerial photography annotating total parking availability on the map, then averaging the total available stalls. After the council remanded the parking, staff realized more resources were needed, and they recruited the assistance of city engineering to develop a spreadsheet, incorporate geographic information systems, as you see here, and have an engineer conduct the same survey over the same hours, including the 12:30 time slot, as remanded by the council. Using GIS, they accurately annotated each parking stall available and exported the information into the Excel spreadsheet included within your packets. So as you see here, you can see the overall information based off of certain segments of the road, the times from the 9 a.m., 12:30, and the 2 p.m. study. I then entered the original counts into the same spreadsheet that engineering developed, which brought to light some inconsistencies in my baseline park totals from the original staff report. And I'd like to clarify that the baseline parking stall total is accurate at 320 parking stalls within 600 feet of the subject property. It is important that the overall availability of stalls are consistent with the original inventory. So here's the original parking data as entered in by the engineering department's spreadsheet. Some important notes: 104 overall average available parking stalls. The 9 o'clock survey included 116 average available stalls, and the 2 o'clock survey included 95 average available stalls. In the second portion of that packet, the 11 by 17s, included the remanded parking data. Important information derived from the study, as indicated by the remanded parking data, included 115 overall average available parking stalls. The 9 o'clock study averaged 139 available stalls, and the 12:30, which was part of the key information that the City Council was looking for, included 100 average stalls available. The 2 o'clock showed that 99 average stalls were available. So given that information, the average 9 o'clock study for the original included 116 total stalls. The 2 p.m. incorporated 95 total availability on average, on a weekly average. The remanded study included the 9 a.m. stalls of 139, as indicated again, the 2 p.m. with 100, and then the 99 available at 2. So that is the information as requested based off of the parking study. The second course of action is to review the method of parking mitigation determination. The off-street parking is not required in the central business zone, but educational institutions in the central business district have specific considerations given to parking. The zoning code includes a parking requirement for education institutions outside central business, which would require 104 total spaces if this was located outside any other district than the central business district. With that, staff explored 3 different parking demand scenarios that would likely result from the common permitted uses within the central business district. Scenario 1 was prior use as a nightclub. As per city code, dance halls require a 1 stall per 100 square feet for dance halls as far as the square footage is concerned. Restaurants, bars, and lounges require 20 plus 1 every 100 square feet in excess of 4,000 square feet. By doing that math, based off of the overall square footage, it would require 127 spaces to be utilized or previously utilized as a nightclub. Scenario 2 included the residential conversion from the prior approved CUP, which would include 1-bedroom studio apartments, the requirement per the Moscow City Code for parking stalls outside of central business for the individuals within a bedroom studio apartments would require 1.25 per dwelling unit, which would result in an estimated 38 spaces. Scenario 3 was the conversion of mixed commercial and office, which includes unspecified retail use, personal services, and our zoning code states that 1 out of every 400 square feet would be required for parking, excluding passive travel, storage, mechanical, and plumbing.